My name is Harold Finch, and I was 63 years old the morning I stopped leaving voicemails for my son and started doing something he was not going to be able to ignore. I had a legal pad on the kitchen table with 43 tally marks on it. I had a cup of coffee going cold next to it. I had the deed to the house on Calder Street in a manila folder under my left hand, and I had Nora Selby's number on my phone, and it was 6:19 in the morning, and the Mordecai neighborhood was completely still. Welcome back to Dad's True Revenge, the quiet corner of the internet where accounts get settled. If you've ever sacrificed while someone took the credit, this story is for you. Drop a comment and be sure to subscribe. You're going to love it here. I had practiced family law in Raleigh for 31 years. Sole practitioner, no partners, office on Person Street 3 blocks from the house where I had lived since Marcus was 4 years old. I knew estate law the way a carpenter knows wood. Not because I had studied in the abstract, but because I had spent 3 decades watching what happened to families when the paperwork was wrong. I had seen houses lost. I had seen inheritances contested for years, while the people who built them watched from nursing homes. I had seen sons and daughters become strangers over documents that could have been written clearly and were not. I was not going to let that happen to me. Not on Calder Street. Not to this house. Marcus was 29. He had grown up in the 4-bedroom on Calder Street, in the room at the end of the hall with the window that faced the oak tree, the one I had planted the spring after he was born. He had done his homework at the kitchen table I built myself over a long weekend in 2004, the one with the slight warp on the left side that he always complained about and that I had always meant to fix and never did. He had left for college at 18 and come back at 26 with a wife named Diane, a marketing job in Durham, and a set of assumptions about the future that he had never discussed with me directly, but that had become, over time, unmistakable. His mother Patricia had left 9 years before. We had been married 22 years. She moved to Charlotte with someone she had met at a conference, and I had not spoken to her more than twice since the divorce was finalized. Marcus had been 54 when she left, and I had been the one who stayed. I drove into lacrosse practice every Tuesday and Thursday for 4 years. I made dinner every night for 9 years. I paid 14 law school application fees, $2,400 across the batch, out of the household account, because Marcus had wanted to consider his options carefully, which I respected, even though he ultimately did not go. The house on Calder Street had been in my name since 1993. I had refinanced it twice to keep Marcus's community college tuition current, once in 2011 and once in 2013, and I had done it without telling him because I did not want him to feel the weight of it. I kept the property taxes current through 2015, the year my practice income dropped to its lowest point since I opened, by taking on 3 additional pro bono cases to maintain my bar standing in Wake and Durham counties, which brought in no money but kept my license active and my referrals intact. I had not taken a vacation between 2009 and 2016. I had kept the overhead manageable by doing my own filing, my own scheduling, and my own billing until practice recovered. The house was worth $387,000 by the February that Marcus and Diane started talking about it, as though it were already theirs. My stomach turned the first time Marcus suggested I let them handle things. He had said it casually, in the kitchen, on a Sunday in October, standing at the counter with a coffee cup, looking at the cabinet that needed repainting, which he had not offered to paint. His voice was even. He was not threatening. He was doing what people do when they have decided something, and are simply working towards stating it clearly. My throat went dry at that. I did not say anything that Sunday. I made a note. There was a folder I kept in the bottom drawer of the desk in my home office. The room Marcus had used for storage since he moved back to Durham. The folder had a label on it that said Calder ST in my handwriting, and inside it was every document related to the house going back to the original purchase. The 1993 deed, both refinancing agreements, the property tax receipts, the homeowner's insurance renewals, and, from 1991, the original survey map with the property lines marked in red ink. I had looked at that folder more than once in the months after Marcus started visiting more frequently, always with Diane, always with a list of observations about the kitchen or the gutters or the back bedroom that needed updating. I had first named that folder to myself, not to anyone else. Sometime around the 3rd Sunday visit, when Diane had asked in what I recognized as a professionally warm tone, whether I had ever thought about downsizing. My hands had folded on the legal pad that morning. I did not answer her question. I noted the date. The conversation that changed the temperature of things happened on a Tuesday in January at 6:44 in the evening. In the living room on Calder Street, Marcus and Diane had come for dinner. I had made the same pot roast I had made on Tuesdays for 20 years. We had eaten without incident. Afterward, Marcus had asked, quietly, if we could talk about the house. I said yes. He sat across from me in the chair that had been Patricia's chair, the one with the worn left arm I had never reupholstered. He had his hands on his knees. Diane was on the sofa. She had a notepad. I noticed the notepad. Marcus said they had been thinking seriously about the future. He said they loved the Mordecai neighborhood and had always imagined being nearby. He said they were at a point in their lives where they needed stability. He said, and here his voice shifted slightly into a register I recognized from family court, the register of someone about to say the hard part, that he and Diane had talked about it, and they felt that I was not really in a position to make long-term decisions about the house on my own. My breath stopped. I didn't answer. He kept going. He said he was not questioning my capabilities. He said it was just that the house required maintenance I might not be able to manage indefinitely, and they wanted to be proactive. He said they had some ideas about how the transfer of ownership might work in a way that was fair to everyone. Something in me went cold at long-term decisions. I had drafted wills for 40 years. I had watched families use that exact phrase, not in a position to justify moving assets before a parent understood what was happening. I had spent 3 decades on the other side of that language. I knew what it meant. I knew what came after it. My hands went still on the armrest. Diane said they had already spoken to a contractor about the back bedroom. I kept my face still. The contractor. The back bedroom. The notepad on her knee. Marcus said it was a family decision. He said he hoped I understood they were coming from a place of love. I nodded once. I waited until they left. I stood at the window and watched their car pull away. It was 8:22 p.m. I went to the kitchen. I got the legal pad from the bottom drawer. I made a new tally mark, the 30th, and wrote the date next to it in the phrase, not in position. I had kept every date of every unanswered call going back 14 months on that same legal pad. Marcus had stopped returning calls the previous November, 2 weeks after I had declined to sign a form Diane had sent by email that would have added both their names to property tax account. I had not signed it because I had not been asked. I had been presented with it, which is different. And I knew the difference between being asked and being managed, and I had spent 31 years making that distinction for other people's families. I refinanced my memory of that Tuesday for the next 2 weeks. Then I called Nora. Nora Selby had been my paralegal for 11 years before she went back for her law license. She had been practicing estate law for 6 years at a small firm on Wake Forest Road. I had referred her first 3 clients to her. We had stayed in contact in the way that good working relationships stay in contact. Quarterly, mostly, for coffee or a quick question about a filing. I called her at 7:44 in the morning on February 11th, which was a morning after I had left voicemail number 43 for Marcus. A quiet message, 3 sentences, wishing him a good week and asking him to call when he had a moment. He had not called back that day. He had not called back the day before. The 43 marks were on a legal pad in a column that went back to September 4th, which had been my birthday, which had passed without a message. I told Nora what I needed. She was quiet for a moment. Then she said, "You've already drafted the language, haven't you?" I had. I told her where to find it in the shared drive. She said she could have the charitable remainder trust document ready for review by end of week. I said that was fine. I drove to her office on Wake Forest Road at 9:02 that morning with the Calder Street deed in a manila envelope and the legal pad in my briefcase and the original 1993 survey map folded flat at the bottom. Nora Selby drafted the charitable remainder trust document and notarized a quitclaim deed on February 14th. The trust named me as sole trustee and designated a Raleigh housing nonprofit as a remainder beneficiary upon my death. It preserved my right to live in a house on Calder Street for the remainder of my life. It made the property non-transferable without trustee consent, my consent for as long as I lived. It named retired Wake County Family Court Judge Patricia Odom as backup trustee, a formality Nora insisted on and which I agreed was correct. Victor Hale at the Wake County Recorder's office filed the deed transfer at 11:18 a.m. on March 3rd. I drove home on Calder Street at 2:33 in the afternoon. I made coffee. I sat at the kitchen table with the warp on the left side, and I looked at the legal pad, and something in me went quiet. A quiet man with the right paperwork has never needed to raise his voice. I had known that for 31 years. I had simply forgotten, for a little while, that it applied to me too. Marcus did not know about the trust for 11 days. In those 11 days, he called twice. Both times about the back bedroom, both times about the contractor's availability. I did not return either call. On March 14th, a Monday, he called at 8:47 in the morning. I was in my office on Person Street, which I still kept 3 days a week out of habit, and because the light through the east window was good in the mornings, his voice on the voicemail was different from the January voice, less measured. A note in it I had not heard since he was a teenager and had wanted something he did not know how to ask for directly. He said he had heard something from a colleague who did county recorder searches. He said there must be a mistake. He said to please call him back. My stomach dropped at must be a mistake. I let it go to voicemail. At 10:14 that morning, Marcus arrived at my office without calling ahead. He came into the front, which he had done perhaps twice in his life, and sat in the client chair across from my desk. The same chair where I had sat with hundreds of families over 31 years. The chair where people sat when something had gone wrong, and they needed someone to explain what the paperwork said. He had printed the county recorder filing. He set it on my desk. His hands were slightly unsteady. He said, "Dad, what is this?" I said, "It's a charitable remainder trust. It protects the property." He said, "From who?" I said, "From any decision I might make under pressure that I would not make on my own." He started to say something about the contractor. His voice had gone tight. I said, "Marcus, the house is mine. It has always been mine. The trust preserves that for my lifetime. Nothing about your access to the house has changed." He said Diane was going to be upset. I kept my face neutral. I said I understood. He sat with that for a moment. Then he said, quietly, not the family court register, not the management register, just his own voice, "Why didn't you tell me?" I said, "You weren't returning my calls." The meeting the three of us had on the Wednesday, March 16th, at 3:07 in the afternoon at the house on Calder Street, was a meeting that settled things. Nora came. I had asked her to come not as an attorney in the adversarial sense, but as the person who had drafted the document and could answer technical questions accurately. Marcus and Diane arrived at 3:05. Diane had a different notepad, a smaller one. She sat at the kitchen table. Marcus sat across from me in the chair with the worn arm. Nora set the trust document on the table. She walked through the relevant sections in the order they needed to be understood. She explained the non-transferability clause. She explained the trustee's structure. She explained the remainder beneficiary designation. Diane asked if the trust could be reversed. Nora said it was irrevocable. Diane's face did not change. Her posture changed slightly. A shifting, a settling, the kind of physical adjustment that happens when a structure someone has been leaning against is no longer there. I paused. I looked at Marcus. He was looking at the table. His hands were flat on the surface. I said, "I built this house. I mean that in every sense. I painted every room in it. I put the floor in the back bedroom this summer, before you left for college. I kept it through the divorce. I refinanced it twice to keep your options open. I was not going to let it become something that happened to me." I kept my voice level. I did not say anything more than that. Something behind my sternum steadied. Marcus looked up. His eyes were a little bright. He did not say anything for a long moment. Then he said, "I know, Dad." That was all. In the weeks that followed, Marcus and I spoke more than we had in 2 years. Not easily at first. The first call was short, 8 minutes, mostly logistical. The second was longer. By April, we were talking on Sundays, which we had not done since he was in his mid-20s. Diane did not call. I did not expect her to, and I did not require it. The house on Calder Street stood as it had stood. I repainted the cabinet in the kitchen that Marcus had noted needed repainting. Not because he had mentioned it, but because it did, and because I had the time, and because the kitchen is mine, and I take care of what is mine. On the first Sunday in May, at 11:32 in the morning, Marcus called and asked if he could come by. He brought coffee. We sat at the kitchen table, the one with the warp on the left side, and we talked for 2 hours about nothing important. It was the best conversation we had had in 3 years. Harold Finch, 63 years old, and still the only name on the deed. Some things are worth the silence of 43 voicemails. Some things require you to stop asking and start filing. And some inheritances are not property at all. They are the knowledge of what property is worth, and who it belongs to, and why the paperwork has to be right. Some things are worth the silence. Some things require the right document. And some houses are only a house until the man who built them finally stops waiting to be heard. Have you ever waited for someone to come back and decided the only thing left to do was act? Leave your answer in the comments below. If this story hit close to home, hit that like button and subscribe for more real, raw, and family-centered stories. And as always, thank you for being a part of this sphere.